Hello everyone, myself Madhuri, Associate Professor, Department of Law, Padmavati University. Today we are going to discuss about what is a company, how it is going to work in a society. A company means it is a body or an entity that has a separate legal existence from the members who comprise of it. So it is a legal fiction that has been created by the Companies Act 1956, and it is an independent corporate personality that it's confirmed upon a company on its creation. It's very unique in its features, and for instance a partnership has no existence apart from its members. There are different types who contribute in various ways to the working of a company. When a company is being incorporated, the individuals setting up the company will have an idea what they want and how it is going to be incorporated, and they can choose from choices that may be according to the identity, ownership and liability. Perpetual existence is nothing but a company which is set up, it may continue to exist and functions until it has been wound up or object for which it was set up and achieved. Key aspects, if you want to say, capacity to sue or to be sued. Deriving from the notion of separate legal entity, it follows that a company has a capacity to sue against the wrongdoer and has the capacity of being sued for a civil wrongs. Limited liability, the business always involves an element of risk. Sometimes the risk leads to high returns and sometimes to losses. Monetary liabilities are bound to occur in the occurrence of course of conduct of any business, and they can easily transferable shares. Anyone who contributes financially towards the working of a company by buying a share, the company owns that much of a particular company. Every shareholder is thus partial owner of a company. In a private company, there cannot be more than 50 shareholders, which is restriction on the transferability of the shares. Compliance and regulations regarding that. Company law is constant updates and amendments to adapt changing business environments and societal needs. It ensures that business complies with various regulations such as environment and labor laws. Dissolutions and liquidation, if you want to talk, it governs the procedures for dissolving or winding up of a company, includes distributions of assets to creditors and shareholders. Private and public company speaks about that a private company is one where the stakeholders of the company, whoever has a stake in the companies and not the members of a general policy. There are members to whom the shares have been offered, or they may be promoters or the directors. There are a few other differences which we can see in a public and private companies. In a private company, minimum number of a member is 2, and whereas public company is 7. They are required to start a particular business. There is a restriction on the maximum number of members for the private company, and that is 50, and whereas a public company is no limit for that. Key aspects, if you want to see, capital structure and merging and acquisitions we can talk. Company law regulates the issuance shares and other forms of a particular capital, as well as rules relating to raising funds, issuing dividends, managing share capitals. Merging and acquisitions, it provides guidelines for the mergers, acquisitions and restricting of a particular companies. These regulations aims to protect the interest of various stakeholders and prevent unfair practices. Formation and incorporation, if you want to talk. Company law always the procedures for establishing a company includes registrations and incorporation processes, and at the same time it specifies the types of a particular company and that can be formed, such as public companies, private companies and non-profit organizations. Government corporate governance, if you want to talk, it's a framework including roles and duties of the directors and officers, as well as the rights and protections of our shareholders. This includes issues like fiduciary duties and transparency requirements. National Company Tribunal Act, we can say that company, that means Supreme Court recently validated setting up for an overarching corporate law tribunals that will take up the company law disputes pending with the Company Law Board. Board for Industries and Financial Reconstructions and various industrial and at the same time high courts. Amendments were made in the Companies Act 2002 and paved into the establishment national law tribunals. Kinds of the companies, we can say specific companies and they have a jurisdiction over that, and we also have the sole proprietorship also. A partnership act, and at the same time individuals who shares the ownership and the responsibilities. That the different types of partnership includes the general partnership and the limited partnership and so on. And LLC, if you want to talk, it's a flexible business structure that companies expects the particular partnership, corporations and all. And the private companies and the public companies, if you want to talk, separate legal entity we can have in a particular owners in a private limited company. Public limited company is nothing but the company whose shares are freely traded on the particular public stock exchange, and it allows a wide range of shareholders and subject to more extensive regulations. Foreign companies and the holding companies. A foreign company is a company registered under the different countries from each, and at the same time the business operations. It may establish a presence of another country through subsidiaries of a branch or branch offices. Holding company is a company where the prime or primarily owned and controls the company's shareholders and the shares, subsidiaries and the shares. It does not engage in active business and at the same time operations, but also plays a particular role. Functions, if you want to talk, bankruptcy resolutions and at the same time adjudicatory disputes we can have it. Non-profit organizations and the joint venture also will be coming under this. When they allow 2 or 3 parties to collaborate while retaining their separate legal entity can be called as a joint venture. And non-profit organizations we can call about the formed for the purposes other than the profit, such as charities, religion groups and social enterprises. Thank you.